Thank you for that last panel and discussion. Mignon, Jim, we like to make our board members do a lot of work at Benton. And Rochelle, who I hope is already on her way to the airport. But also Larry, Blair, Chris, thank you so much. I think that conversation really sets us up well for this one, sort of bringing out the foundational fragility of the Universal Service Fund and the factors leading up to it. And speaking of factors leading up to it, it is my pleasure to hand the mic over to, not literally, to Gigi Sohn, Benton Senior Fellow and Public Advocate and Ambassador Verveer, to talk about the structural preconditions that led to the Telecom Act of 1996. Thanks, Gigi.
Great. Good afternoon, everybody. And it is such a privilege for me to introduce my friend and former FCC colleague, Ambassador Phil Verveer. Now, those of you who read my LinkedIn probably saw that I called Phil the GOAT, the greatest of all time of telecommunications policy. And let me tell you why. In his decorated career, Phil has been, among other things, and yes, I have to read because it's a very long list, Senior Counselor to FCC Chairman Tom Wheeler, where we work together, Ambassador and Deputy Assistant Secretary of State and U.S. Coordinator for International Communications and Information Policy. That's a title that's even longer than Larry Irving, so congratulations, you win. Chief of the FCC's Cable Television Bureau, Broadcast Bureau, and the Common Carrier Bureau, a supervisory attorney in the Bureau of Competition at the FTC, and perhaps most importantly for our conversation today, a trial attorney in the Antitrust Division of the Department of Justice, where he served as the division's lead counsel in the case that resulted in the breakup of AT&T in the 1980s. And he's prominently featured in one of my favorite books. I really don't usually like nonfiction, but this nonfiction reads like fiction. It's called The Deal of the Century, The Breakup of AT&T by Steve Coll. So I highly, highly recommend it. And Phil plays a huge role, at least in the beginning of the book. So please read it. It's heavy. Okay. So Phil, delighted that you're here today. Thank you so much. And why don't we start with the questions? And a lot of these questions are, so we trying to make sure we don't repeat what everybody else said. That's what Phil was worried about. A lot of these questions are going to be, looking back on your experience of the breakup of AT&T. What does it mean for X? So the breakup was structural intervention that reshaped American telecommunications for over a generation. So how did that experience shape your understanding of what the 1996 Act was trying to accomplish and the challenges to achieving those goals?
Well, it's clear, I think, that it is on? Okay. I think it's clear that the 96 Act was necessitated, in a sense, by the unsustainability of what had fallen out of the AT&T settlement and the divestiture, because there had been a kind of war of all against all in the courts and at the agency that had followed the divestiture. And it was a situation where the court, Judge Green in particular, had done a terrific job of refereeing and trying to oversee this. But it was plain institutionally that this was the wrong place for these issues to be addressed. So what the 96 Act did, among the great many things that we've been talking about today, is it placed the responsibilities back with a regulatory agency, which is where one would be best equipped to try to deal with them. That's something that has enormous implications for all the discussion we've had about AI and what might have to happen with respect to AI in the future. So the structural aspect of this thing was enormously important. It looked like a pretty clean way of trying to contend with the monopolization issues that were running around loose in the AT&T prosecution. And in many respects, it was a really successful way of dealing with the problems. The difficulty is that even in an environment that was a lot simpler than the one we have today, there are an awful lot of questions day to day questions that had to be contended with somehow. Questions like what kind of interconnection is appropriate from an architectural, physical perspective, from an economic perspective? How do you contend with the question of universal service funding if the internal subsidy arrangements have been disrupted with respect to by virtue of the divestiture? So there were terrifically difficult questions that finally came to a head in 1996. And the way in which those questions were addressed, as the panelists have been discussing all afternoon, had some really positive aspects to it and some rather less than positive aspects to it.
Would you like to expand upon the positive and negative? Even if you don't like to, please do.
Sure. The difficulty, of course, was that a lot of what you find in the 96 Act was very highly detailed, very specific, and turns out within a relatively short period of time entirely irrelevant because the technology was evolving very, very quickly. And the specifics, many of the specifics were addressed, particularly with respect to narrowband telephony, if you will, ceased to be very, very important pretty quickly. It also is the case that, as again the panelists have described, there were an enormous number of regulatory requirements with very tight deadlines that had been incorporated into the Act. And again, those requirements, as they were being dealt with, often turned out to be, to describe it a little bit uncharitably, sort of wasted effort because the technology overran a lot of the issues that were being dealt with. Now, there are, in my way of thinking, two really large elements to the 96 Act that need to be contended with today. One is what we've been talking about all afternoon, which is the question of universal service. How do you fund it? We have not done a wonderful job in terms of dealing with that over the last 30 years. Obviously, the pivotal question is one of jurisdiction. The question of how to think about the jurisdictional question: is it just narrowband telephony, or does it include broadband? That's something that has to be resolved sooner rather than later. And as the panelists have suggested, there's not much reason for optimism. It will be, but it really needs to be addressed. And of course, the other thing is Section 230, which we could talk about almost endlessly, I think, in terms of trying to figure out what might be optimal here in the United States, given the issues that Section 230 presents and the existence of the First Amendment.
I'm gonna continue to pull on some of your strings there rather than go to my next question. On the jurisdictional question, there was talk, and Blair mentioned how there was some agreement that, you know, those that benefit from riding on the network ought to pay something in, like how they do it, how you'd measure it. Of course, those are details that, you know, who cares, right? Who cares about details? I mean, what are your thoughts about that? What are your thoughts about broadband paying in? Clearly, it's not sustainable the way it is now. So, you know, and obviously, if the edge is going to pay in, you'd need to expand FCC jurisdiction. So what are your just general thoughts about, you know, who should pay in and how do we fix that, if possible?
As we now know from consumers research, it's not a tax. It may be something else, but it's certainly not a tax.
Thank God.
Yes, we don't want to, whatever else, we don't want to call it that. But as a practical matter, of course, you could fund it any way that you wanted to fund it. The obvious kind of heritage of what we had for the many, many years when it was an internal subsidy would suggest bringing broadband into it and finding a way to impose a charge on the broadband transmission services and take care of the economics of it that way. That'd be the simplest way to do it. If you begin to want to bring in big users of the broadband transmission networks, those that arguably impose costs on it. It obviously gets a good deal more complicated, but the Congress could do that if it wished to as well. The reality, which has been addressed over and over again now this afternoon, is that we have very, very important reasons to want to address the affordability issues as well as the other related issues that universal service encompasses. And if we're going to have a decent, just society and an efficient, effective society, we're going to have to find a way to deal with that.
So the breakup of AT&T and the 96 Act were both premised on the idea that competition could achieve what regulation could not. So in your opinion, that premise, has it held up? Does it still hold up?
In the right industrial circumstances, I think it certainly does. That is to say, if you have sufficient amount of competition, you will get really better outcomes than if you ceteris paribus attempt to regulate. The difficulty I think we confront going forward is the question of, do we have that much competition in the sectors and the areas that we care about? And I think it's pretty fair to suggest anyway that we probably don't. And if you think about the present competition with respect to AI, it looks like it could be one of these situations where it's literally winner take all. That is to say, it is entirely possible that we'll end up with an entity that is utterly predominant in terms of AI. We could put a name on it, but none of you would be surprised at the name that one wanted. We could say Google if we wanted to be precise about it, I guess. And if you have something like that, if you don't have a workably competitive environment, then obviously competition isn't going to work. You're going to have to revert to some form of regulation, which is, in fact, what I think we will have to end up with.
So let's talk about remedies a little bit, okay? So, antitrust and communications regulation, they operate on parallel tracks. Sometimes they're in tension. But in today's market, when again, let's get back to broadband. I want to pull on the AI string just in a minute, but when you have so few providers, and we just had Cox and Charter merge and Verizon Frontier, just consolidation. And look, I know very well the experience of small fiber companies. It's tough to survive. I think you're going to see more consolidation. Are the existing tools of antitrust and regulatory law adequate, or are there other remedies that we need? I mean, do we need to go back to, we really don't think about structural remedies anymore, right? I mean, do we need to think harder about structural remedies, or are there other remedies that you could think of for this highly concentrated market?
Well, when we want to discuss structural remedies, one of the questions we have to ask, I suppose, first and foremost, is where do we think they're going to come from? And if you look at the monopolization cases that have been brought and decided to this point with the remedies that have been suggested, you have to believe that it'd be very optimistic to look at Section 2 of the Sherman Act and think that that's going to present structural remedies for us for a lot of reasons that are pretty easy to understand. Even when judges find liability, they're going to be very, very slow to want to impose structural remedies. We probably haven't had one. I think it's fair to say we haven't had one since the AT&T case. And it's, I suppose, further worth observing that in that circumstance, one of the arguments was things weren't as dynamic as they might have been. They weren't as dynamic as, in theory, they could have been. Right now, we have a great deal of dynamism. So you have, for instance, Judge Boasberg's views with respect to Meta, and more especially, I think, Judge Meta's views with respect to Google search, in which he says, gee, a lot is going on here. I don't think I should consider structural remedies in any very serious way. So first and foremost, there's that. But secondly, even if you assume, contrary to what our panelists have said over and over again this afternoon, that Congress is going to step up and address this somehow. It seems to me that the industrial setting is one in which one would not feel as though we are likely, even with trying to break up companies or whatever, that we're likely to end up with a terrifically competitive environment. Network effects and things of that nature are going to make it very, very unlikely that in an environment with enormous fixed costs, enormous financial requirements, that we're going to have anything like a workably competitive environment. And if that's the case, then it seems to me that you inevitably end up thinking if there are going to be any social controls, they're going to have to be of a regulatory nature.
Okay, so how do we get there? Okay, how do we and let's push it. You know, you mentioned AI several times, and you know, you and I discussed about how the thing that's most interesting about the 96 Act to you is how it might, what the implications might be for AI. So are you saying we should have a regulatory agency for AI? I mean, how do we deal with this animal that that we're just learning now how powerful it is?
Well, I think eventually we are going to need a regulatory agency for AI. I think it's just almost a dead certainty. We're not going to be able to rely upon, as one kind of appears today, to rely upon the laws of contract, property, and tort and figure out that everything's going to work out really well in terms of AI. We're going to have some sort of specialized legislation, specialized laws that try to address the issues that AI is going to present, whether we think of them as competitive issues, we think of them as broader cultural issues, we think of them as issues of equity, privacy, all the rest. So I think that we're going to have to get there, but the problem, as has been described over and over again, is it is really unclear how any time in the foreseeable future we're going to have Congress in a position to try to address what, to be fair, are going to be very, very difficult questions.
That's depressing. Okay.
Well, remember what I took a lot of sort of consolation for something Chris Wright said, which was the way things are arranged, it'll be hard to make things worse. And I thought, well, that's that's kind of a nice way to think about this.
Yeah, I guess my issue, I mean, look, some of my former colleagues, Harold, Tom, you have talked a lot about having, a regulatory agency for the edge. And I kind of go back and forth about how I really feel about it. Part of me is like, yeah, regulate them up to the yin yang. And then I'm just like, well, but there's, you want to be mindful of innovation. You want to be mindful of First Amendment concerns. So, I don't know where I come out on that. I'm not sure I am as certain as you that we need an AI regulatory body. I mean, how do you kind of thread the needle between some of those concerns about innovation, speech, and protecting the public? I mean, it seems to me, there's so much talk about AI this, AI that, right? But AI is really just another general use technology that exacerbates all the problems people in this room have been working on for years, right? Non-discrimination, privacy, universal access. We heard this, I think, in the first panel. So I guess my question is, how do you structure, and we don't have enough time, I think, to give a complete answer, but I guess you believe that there is a way to structure an agency that can kind of skirt around some of my concerns and get at the nut of what we're concerned about.
Well, I'm certainly not suggesting that I'm sure that it can be done or that it can be done easily. But it seems to me that what we will need to do is have ultimately a law that has jurisdictional reach that is appropriate, that will have a set of goals that are described in a kind of high-level way with some sort of an apparatus that tries then to effectuate those goals and is able to make adjustments from time to time as will be required. And I think also, and this is very important, Gigi, with the point you've just been raising, the potential downside, that we should try to instruct an agency only to intervene in the context of aggravated circumstances. That is to say, to have not a quick trigger, but a slow trigger in terms of intervention. But we need to have some entity that has the undoubted ability to intervene in the event of aggravated circumstances. And we surely don't have that today.
That is a fact. Okay. I think you're going to say a lot of what Blair said on the previous panel, but I'm going to ask it anyway. So we heard from Larry that Representative McClellan is talking about, relooking at the Telecommunications Act. Every, I would say, 2 or 3 years, there's a wave of interest in a new Communications Act. Do you think it's a good idea? And if so, what should the tent poles be? What should the principles? We have heard a lot about principles today, and that seems to be what got the 96 Act going, was agreement around principles. So tell me what you think about a new Communications Act, and what should the core principles underlying it be? And are they different, really, from what the 96 Act did or the 34 Act did?
Yeah, I actually think the 34 Act provides an interesting template, anyway, for some sort of regulation going forward, because it basically not only had a kind of set of purposes that seem like they're pretty universal purposes, pretty legitimate set of purposes that could be adaptable or adapted pretty readily. But it also had a set of instructions, and I think of this particularly with respect to Title II, it had a set of instructions that, while relatively abstract, gave the agency an opportunity to try to help move things along in ways that were in the public interest for a very, very long time. And I think something similar to that, where you have requirements that the way in which the entities subject to jurisdiction proceed in ways that are just and reasonable, that are not unduly discriminatory and so forth, are probably the right kind of ways to think about how we would like to see some sort of social controls going forward with respect to these technologies as they're emerging.
But one of the things Blair said, which I unfortunately agree with him, is that unless Congress really explains jot and tittle what it wants, you're going to run into, the buzzsaw of Loper Bright. You're going to run into the buzzsaw of lack of independence in the agencies. I think it gets back to, is Congress I actually think the IIJA, right, the Bipartisan Infrastructure Law, was about as close as you can get, and maybe even too much, where Congress said, you must have, this number of rounds of proposals for BEAD. I know my former friends from NTIA are holding their heads right now. I guess Congress did that, right? But wouldn't we need that here? I don't think it's enough to say unjust and unreasonable, universal service. I feel like if we're going to have another Communications Act, it's really going to have to be super prescriptive. Otherwise, the courts are going to be like, later.
Yeah, I do agree with that. I think we have seen basically the Supreme Court undertake all sorts of decisions that pretty much dismantle the possibility of the administrative state, the regulatory state. And in consequence of that, you have, we have the West Virginia against EPA. We have Wilbur Blank. We have over and over again, Casey, Control Point. Just one after another, and we soon will have the end of Humphrey's executor, presumably. And at that point, you have to ask, will we have mechanisms that will permit us to actually address the kinds of issues that we've been talking about and been concerned about? And ideally, you really don't want to have a situation where, the entire center of gravity is in the old executive office building, where the personnel are going to change every 4 years or every 8 years, and the ideology is likely to change every 4 or 8 years. It just seems to me that from a societal point of view, that's going to be an extremely unfortunate outcome. But our Supreme Court has, both in terms of kind of being in thrall of the unitary executive theory, and also pursuing things in ways that I regard as being so reductive as to reach absurdity in many instances, that we have a really, really difficult time figuring out how we would end up with adequate legislation that would in fact survive all kinds of judicial challenges if it attempts to do anything other than what is within the four corners of a very carefully defined instruction.
All right. Well, we have about 5 minutes or so for Q&A. So he's the GOAT. So this is a good time if anybody has any questions. Greg Geis.
Yes. Hey, thanks, Bill. Great to see you.
See you, Greg.
I'm wondering if on this regulatory agency point, maybe if you had as a foundation of the structure like Title II versus the media portions of the FCC's Title III jurisdiction, if you had a prohibition, except in very extreme circumstances, about looking at the actual content of something, so that you make it where the AI system is really structured around a neutral pipe, not to use a stupid term, but neutrality of like the agency doesn't really dig there. It digs elsewhere.
Yeah, I actually think if we were looking for any reason for hope in kind of what a model might look like, what you might say is, look, let's try to amend the existing Communications Act in ways that you've just suggested, in changing the jurisdictional reach so there can't be any doubt about how it reaches broadband and related things, and also then using some of the substantive provisions as models, again, with an appropriate instruction about let's be careful about intervening if we don't absolutely have to.
Gentleman there. Wait, Jim, wait. Yeah.
Can you hear me now?
Yes.
In thinking about an AI agency, how would you think about kind of the existing regulatory authority in pulling those together? So, for example, NHTSA is building a regulatory framework around autonomous AI vehicles. FDA has authority and has done a bunch of work around protecting us from medical devices when AI. And we just saw DOD this last week, who had a very different view of how to push AI tools. And then we've got NIST, who's got the AI Safety Institute. How do you think about a future administration, for example, having that kind of control when we think about what happened in DOD last week, and pulling the regulatory, I guess, piece out of places like NHTSA?
Yeah, my own view is it'd be a lot better to have something more centralized. What you're suggesting brings to mind some post-traumatic stress problems I have from the interagency process when I was at the State Department, and so you'd like to minimize that if you possibly could. I say I'd much prefer to see something that's more centralized.
Gentleman over there. I think we could probably take one question after that if somebody has one.
Thanks. Mark Bohannon. I worked on the non-telecom side of tech at Clinton and been in tech 30 years. Great to see you again, Ambassador Gigi. I want to leave a footnote about this discussion because it's really starting to weigh on me, which is as Gigi said, we talk about AI, really when we talk about the ecosystems of AI and its concerns, aren't we really talking about the LLMs? I mean, aren't we really talking about the broad consumer-based LLMs? Because most uses of predictive analytics and where the real innovation is, has nothing to do with the LLMs. And it's, off the grid. You can talk about the Genome Project being an example where most of the work is being done not an open way, but, results are open. So I think as we talk about what is it we're going to regulate through this agency, that I say that because I ponder and I see what's going on really with predictive analytics and where the innovation is. And I'm trying to figure out what it is are we trying to regulate?
I think it's a very fair point. I mean, the LLMs obviously have their own issues, but some of the frontier models obviously have their own issues as well. I mean, really remarkably, potentially far-reaching issues. And maybe it's not the same entity that tries to control these things, but again, it does seem to me that some broader effort at social control of this whole range of things is going to turn out to be very important. I just don't see how that's dispensable the way this seems to be headed.
Thank you for that. And John Winhausen will wrap us up.
I'm kind of the same mindset that you are, Gigi, about pros and cons of regulating
I like that.
this industry. But it strikes me that before we legislate through Congress to create an agency or not, we really need an independent commission, study group, or whatever you want to call it, to examine, to define what it is that we'd be regulating, what are the boundaries, to provide some recommendations to Congress. So maybe we should, and I ask Phil for your opinion, it would make sense to set up for Congress to set up some sort of commission to come back and take testimony and then deliver a report of recommendations to Congress about how to move forward.
It seems very sensible suggestion. I mean, again, one of the complexities here is the dynamism of the situation. Unlike the old AT&T business, where we really didn't have an awful lot of moving parts, we didn't have a lot of changes that were occurring rapidly. In fact, that was one of the objections to the structure of the old phone company. Here we have a very different situation, and the question then becomes, if you have a commission, you have something like that, can it keep up with developments, or does it produce a report that within a very short period of time we think, gee, that's all very interesting, but the world has moved on? So it's a really complicated, difficult, I think, set of public policy questions that we're confronting.
Well, this was terrific. I hope everybody could give a hearty round of applause to Ambassador Verveer. And if you do get an opportunity, I hope you can stick around maybe for a little bit after Revati closes us out. He's an amazing human being. So, and he used to be my wife's boss, so that makes him even more amazing. Exactly. So, Revati?